All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. The first case on the docket is the legal women voters case. Counsel?
My name is David King. I represent the coalition plaintiffs. It is our position that the trial court erred in approving the remedial map. And consequently, the first point I would like to talk about is the standard of review. It is our position that the trial court engaged in rational basis review. And as the court knows, that's undergirded by a rule of statutory construction that presumes that the action of the legislature is valid, a presumption of validity.
Well, doesn't the trial court say it's following the standard review in apportionment 1?
The trial court follows a rational basis review initially and continues it all the way through. But the problem is, Your Honor.
My question, doesn't at some point the trial court say that it's going to follow the standard review articulated in apportionment 1?
But of course, yes, sir. But in apportionment 1, there was no finding of an intentional violation of the Constitution. This trial court found that the political operatives conspired together to influence the map, that they made a mockery of the public process with the shadow process, that they made great efforts to try to keep what they did secret, that they succeeded in influencing the redistricting process and the redistricting plan, that they tainted the map with improper partisan intent. Now, once the court finds that, once the court finds based on extrinsic evidence that there has been an intentional violation of the Florida Constitution by the legislature, that the legislature will not follow the instructions that the people of Florida, the standards that they put on the legislature for the redistricting process, then at that point the rational basis test is no longer appropriate. There are two reasons why the court should have approached this from a standpoint of strict scrutiny. One is that almost all the districts that are contested involved racial classifications, districts that were formed predominantly for racial purposes. That strict scrutiny, was the action of the legislature benign, or was it a misuse of race without compelling justification? But the second reason is, look, when the legislature has intentionally violated the Constitution, and when the standards they've violated involve voting, which this court said the right to pick your representatives, and the process by which you pick your representatives is the bedrock of democracy. So if what they've done is not a violation of fundamental rights, there couldn't be such a thing. You apply strict scrutiny.
Can I ask you this? Is there any place in either the final judgment or the order approving the remedial redistricting plan where the court actually says that it's applying rational basis review?
No, sir.
Okay.
But what you do find in there is the court saying that we have a limited role. Well, I submit to the court that the trial court does not have a limited role after the trial court has found an intentional violation of the Constitution. At that point, the court has the responsibility, as you would under strict scrutiny, to unwind the improper partisan intent that the trial court found in the map.
Okay, so assuming that you're correct, that at the point he found improper intent as to the whole process, then the burden would shift. What then should the trial court have done? You challenge some specific districts and you challenge the plan as a whole, what should the trial court have done? And then my next question would be, what should this court do?
The trial court should have no longer accepted
Well, I understand that part, but I'm
Right.
saying as a practical matter, once the judge said that there was improper intent, does the burden then shift, and then what would need to happen? In other words, what's the next step in the way the challengers view this case?
The challengers view that the trial court should have not sustained the decisions regarding District 5, District 13 and 14, District 21 and 22, District 25, District 26 and 27.
So only the specifically challenged districts he should have ordered, should he have then ordered the legislature to go back and redraw those districts?
He should have ordered a much more fulsome and robust responsibility for the legislature to redraw those districts.
Nobody seems to make much of the fact that in drawing the districts, that the 2002 map was used as the benchmark. Now, I understand there has to be benchmarks for those districts that could be subject to voting rights violations. But since the 2002 map, as it relates to Congress, was found by the federal court in Martinez to be admittedly drawn not to discriminate against minorities, but to benefit Republicans, I don't see your brief or the argument being that the beginning with the 2002 map was a problem. Is it a problem? In other words, if we're to accept your argument, do you still use the 2002 map as the benchmark from where the legislature would look at redistricting? Do you understand my question?
I understand your question, Your Honor, and it's our position that I think it's better, rather than talk in terms of the abstract, if it's okay with the court, if you look at District 5 in the prism of what you just said. District 5 was a prism of the plan, the centerpiece really of the plan to manipulate the performance of the congressional districts since 1992. It was also, as the Martinez court pointed out in 2002, utilized for the same purpose, and Judge Lewis found the same thing in 2012. It's our position that 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 you should not be bound by any strictures of the 2002 plan.
As to and I understand District 5 being redrawn affects other districts, but as to the plan as a whole, was that the finding in 2002 about partisan intent was only as to why District 5 was drawn that way, and it wasn't
No,
as
it was
to the
as
whole
to
plan?
the entire plan,
So,
Your Honor.
but you, the challengers, do not have any problem with still using 2002 as a baseline for the other districts?
Well, the challengers challenged the entire plan.
I understand that,
Right.
but again, somebody has to go you're saying either it goes to the trial court, it goes to this court, it goes back to the legislature.
Right.
So in going back, just practical speaking, where does the 2002 benchmark fit into what you would, if you were directing the legislature to do something, would you say don't start with the 2002 map, start with just blindly, looking at compact districts and not worry about the 2002 map?
I would tell the legislature start with the Constitution and follow the provisions in the Constitution.
I understand. That doesn't really bring any clarity to this. Let me ask another question. Do the parties agree as to how to measure whether a district performs Democratic or Republican? What I'm seeing is that both sides seem to cherry pick. They got the 2008 election, the 2010 election, the 2012. Sometimes someone goes back to 2000. There's sometimes averages. How do we, in looking at this, and how did you ask the trial court to look at how you decide whether a district performs Democratic or Republican?
We looked at the 2008 and 2010 elections separately. And then since we were
But okay, so you would say that, but what
Yes.
is wrong? So does the legislature disagree on?
I don't think they do. They consider from time to time the 2012 results, because sometimes the 2012 results show what occurred after that. But at the time the legislature was doing it, all they had were the 2008,
So they don't go back
2010.
to look at 2000, and, you know, just the whole area? Because if you look at 2010, we know that that was a year that, you know, maybe there were some other occurring factors, or it's
Right.
different in a presidential year than in a non-presidential year. And it seems it's not a very scientific way to decide whether a district is going for one side or the other. So
It's not scientific, Your Honor, but 2008, a presidential year, 2010, a non-presidential year. So that gave you a pretty good indication of the
And
vote.
what about the idea that if in looking at a plan, the question of whether it's a competitive district? In other words, what we're trying to, I think the voters were trying to create something where it wasn't solidly, there are just Democratic districts and Republican, that there's actually something known as competitive elections. So is it important in looking at it as to whether the map created competitive districts so that either a Republican or a Democrat could have a shot, since we know many of these districts are actually influenced by what the independents do?
Your Honor, that's certainly important. What we found the most important was to try to unwind the partisan actions of the legislature. In other words, when we found a district like 13 where they made a decision that violated the compactness rules, the boundary rules of the Constitution, and it actually flipped the seat. It made it a Democratic, it made it a Republican seat. In 26, where they split Homestead, and that actually made the seat a Republican seat. And then in District 5, where they ignored the opportunity for other minority ability to elect districts to keep the configuration the same in a situation which, as the court knows, historically performed so well for the minority candidate from 1992 to the present, even though the voting age population has ranged as low in District 5 during that time as 42.7 in 1996 and 46.9 in 2002. So despite that, the legislature continues to seek these large, under the 9057, District 5 will perform for the minority candidate at the 69% range under the 2008 election. And yet at the same time, the East-West division of District 5 that we propose will perform in an area of 64%.
What is it about the East-West configuration that you propose that is constitutionally superior to the remedial district that was enacted?
I think there are 5 things, Your Honor. It's more compact
than... compactness is... It certainly is longer. It stretches a further distance than the enacted remedial district, correct? So if you look, that is something that you would at least, a factor in evaluating compactness would be the geographical extent of it.
It's
one factor.
One factor. It's more compact, though, under the measurements that the court and the parties have used. It breaks less counties. It makes the surrounding districts in central Florida more compact. It creates the opportunity to make District 10 an ability to elect district, so that as a result of that, what you have, even though the legislature claims they're involved in minority protection, that's their mantra, under the East-West plan, there would be 203,000 more minorities that would be in an ability to elect district. There would be ability to elect districts in the 3 major centers in Gadsden, Leon, and Jacksonville, and in Orlando. That would be an enormous advantage over the present situation. Now, I'm afraid I'm going into my colleague's time.
But one other question. If you were to be the map drawer, is there a map that was introduced in evidence, and I realize that may not be the burden, but that would be the map you'd say, that's the map the legislature should have considered? There's Romo maps,
It would be Romo A, which was the map we argued in the trial court, and it would be, as far as the remedial map, and remember the remedial maps that we offered after that in the remedial hearing in front of Judge Lewis, the remedial map would be Coalition Plaintiffs B.
But the remedial map didn't redraw then, it only dealt with
Just
the top.
the 9 districts that were involved. Thank you, and I'll save my...
Good morning, Your Honors. John Devaney for the Romo plaintiffs. Your Honors, I'd like to begin just by following up on this discussion of strict scrutiny or close scrutiny, and would like to emphasize that in this situation where you have a finding of a conspiracy that infected the entire process with partisan intent, including the public process, the map drawing process itself, that is something that should trigger strict scrutiny.
Why do we have to use the term, I mean, strict scrutiny does have a constitutional basis, but it also, I mean, why not, and maybe this is the argument, that once that's found, the burden shifts to the legislature to justify it, or there's no longer the same deference, I guess, and maybe that's the same. Is that the same as strict scrutiny, or
it could be close scrutiny, it could be strict scrutiny, but clearly a level of scrutiny higher than rational basis was required.
But I don't know. I mean, the question is, I don't think the judge applied rational basis. What your argument is that once he found that the plan as a whole was drawn with unlawful intent, then he shouldn't have. Then he went, when he looked at the other districts, he looked for more flagrant Tier 2 violations, as opposed to looking at those and saying, well, wait a second, when you took a chunk of Pinellas and put it into Hillsborough, that wasn't. You don't get the same deference as if there wasn't that finding of intent. Isn't that, wasn't that his problem? Not that he...
No, that's correct,
Okay,
Your
so
Honor.
I don't think it's fair to say the judge used whatever we consider to be rational basis, and I'd rather, for this argument, not get into what we do in other types of legislative, analysis.
Understood, but the review he did conduct didn't give adequate attention to the fact that there was a finding of a Tier 1 violation throughout this map, that the entire process was infected by partisanship.
Where does he actually say that? That all the districts were affected by the partisan intent?
Your Honor, he finds that the entire map is unlawful, and if you
let me repeat my
and I was
question.
going to continue.
Okay.
And if you read his decision, and he talks about the fact that there was a shadow redistricting process, that consultants were secretly given maps by staffers in the legislature.
Well, the connection between that and the intent of the legislature is a different matter. Now, he draws some lines there with respect to the districts that he invalidated. I understand that, based on some particular circumstances related to those districts. But where is there a general finding that this whole map was the result of a partisan intent? Where is that in the order?
Your Honor, there's a section in the order that talks about the redistricting process in general. That's the heading of the discussion. And in that discussion, the trial judge walks through the evidence of the shadow redistricting process, and nowhere does
I'm
he...
asking for where there's a finding. There are a lot of things talked about there, but I'm asking about this finding of partisan intent that affects the whole map. Is that in there, or do you just infer that that is behind the discussion?
I don't recall a specific finding. However, I will say...
If it were there, you would recall it.
But I will say that the entire discussion, Your Honor, concludes that the process was infected with intent. And if the court were to ignore that, then the whole partisan prohibition in the Fair District Amendments becomes meaningless. And we have a trial judge who found that this process was a shadow process, that literally there were maps secretly being sent from staffers to Republican political consultants, that Republican consultants were submitting maps through false names in the process, and then the legislature gets up and says, we relied on those maps. You look at District 13 and 14, Your Honor. That is a district that matches a district that was submitted by a Republican map drawer, Frank Terra Firma, under a false name. The legislature used that district and then stood up and said, we've relied on Alex Posada's map for this district. And for the court to ignore, to not enforce that you have a Republican-drawn district by a Republican operative would render the Fair District Amendments.
Was there any evidence that the legislature knew that it was an operative who had submitted the map?
There is significant circumstantial evidence, Your Honor, that shows communications between staffers and Republican political consultants. And one can easily infer that there was knowledge. Is there direct evidence? No, there's not. But there is certainly, and the fact that the map that was submitted by Mr. Terra Firma exactly matches the district that was adopted, and there were about something like 90 different maps that were submitted in this process, and it can't be a coincidence the legislature picked that one map.
Is there a finding that there was such knowledge on the part of the legislature? The people that were responsible for drawing the maps?
As Judge Lewis said, the circumstantial evidence is way beyond coincidence, and therefore one should have to infer that there was a conspiracy. And that was his finding. That was his conclusion. I don't remember the page number, but he does say that there's too much circumstantial evidence for there to be a coincidence.
Well, it's at page 11, he says, the circumstantial evidence convinces me they managed to infiltrate the process. They managed to taint the redistricting process and the resulting map with improper partisan intent. There's just too much circumstantial evidence of it, too many coincidences for me to include otherwise. And then he goes through everything from the destruction of the records to the there's emails between Pepper and Reicherfelder from Dean Cannon. I mean, I know you don't have, but I think the judge does go through a lot. But it is true that he puts this general intent section into District 5, which I think the the legislature says indicates he was only looking at this with respect to District 5 or District 10. What do you say about that, about the placement of it?
Well, when one reads the discussion from Judge Lewis, it's quite clear that the discussion doesn't relate just to District 5. And the evidence demonstrated that this secretive shadow process wasn't limited to District 5. It applied to the entire map. In fact, we have consultants who had communications about multiple districts with staffers, including a person who was in the Speaker of the House's office. And it wasn't limited to District 5. So the record supports a broad shadow process that wasn't limited to any specific district. If I could, Your Honors, I'd like to briefly talk about remedy. Our concern is that when you have a map that is infected by this entire process, that you can't selectively preserve any districts, some over others, that the entire map should be declared unlawful because the entire process was unlawful, and you can't parse among individual districts. It's well established, as we argue in our brief, that courts, state courts, have the authority to draw maps where the legislature has demonstrated that it's unable to do so. That began with the Grow decision by the United States Supreme Court.
That hasn't happened here. They were asked to do 2 specific districts. They did it. You're not challenging how one district was redrawn. You are challenging another. So how is this a situation where they've been told to do something and they haven't done it?
Well, Your Honor, of course, we are challenging the finding that only those 2 districts should have been redrawn.
I understand, but as far as whether this court should do it, Judge Lewis, or it goes back to the legislature, let's just assume it needs to go back to the legislature. Do you have specific guidelines can they use the 2002 map as a baseline again?
Several points with respect. If this were to go back to the legislature, one, it should be done with very clear guidance from the court. And I would argue that the 2002 map, because it was admittedly a partisan map, should not be the starting point.
So where would the starting point be?
I would have to leave that to the map makers, and they would have to determine what the starting point would be. But the 2002 map, as as the legislature
So you would
said.
leave it to professional staff, since the judge did find that as to the Alex Kelly, John Guthrie, there was a third person, that they acted in I don't know if they're still there, but that they had the ability to do this in an objective way.
But with very specific instructions. For CD5, adopt the east-west orientation. For CD13, eliminate the split of St. Pete and Pinellas and CD14's crossing of Tampa Bay. For 26 and 27, eliminate the split of Homestead, which divides a racial community. And for CD25, eliminate the split of Henry County. Those should be very specific instructions. Those are all changes that improved Republican performance, that were race-based, are subject to very close scrutiny, and there's no compelling state interest for those redistricting decisions. And it's the state's burden to demonstrate that there was, and they cannot. And I don't want to eat into my colleagues' rebuttal time, so without any further questions, I will defer. Thank you very much.
May it please the court, Raul Cantero. I will be arguing on behalf of the legislative parties. I'd like to begin with findings of fact that are in the record and that the appellants have not appealed. And I think that these findings will allow the court to understand why Judge Lewis did what he did. On page 22 of the final judgment, which is on page 186 of the appellant's appendix, he says, as Justice Pariente referred to, I had the ability to judge the demeanor of Alex Kelly, John Guthrie, and Jason Pareda at trial and found each to be frank, straightforward, and credible. I conclude that they were not part of the conspiracy, not directly aware of it, and that significant efforts were made by them and their bosses to insulate them from direct partisan influence. So I think that explains a lot about what Judge Lewis did, because he heard testimony from these individuals, and they said, I never heard of Alex Posada. I was never instructed to look at a Posada map. I looked at all maps the same way, and he was able to conclude that they were not influenced. So that part of a conspiracy by operatives, he, although he didn't explicitly found it, he implicitly found did not infect the process. What he did find infected the process was on the other side, the communications between Kirk Pepper and Mark Reichelderfer. There was evidence that Pepper was giving draft maps to Reichelderfer. There was no evidence that Reichelderfer submitted any maps back. There was evidence that there were communications between Pepper and Reichelderfer about CD10, and Judge Lewis invalidated CD10, so that's a moot point. There was evidence that Mark Reichelderfer thought—
Let's just go on this issue about that there was evidence. How do we deal with the fact that that evidence, whatever was found by the challengers, generally came from the operatives' emails, that there is no question that he found that all of the emails that might have been back, that there was destruction of emails. Now, and let's just with Dean Cannon, who did have direct email contact with Reicherfelder, but we didn't know that from his emails. So how do we deal with, you say, well, there wasn't evidence, but if the presumption that there are records that are not preserved, so all of a sudden there's no evidence, but there is evidence of some. So how do that's a concern, and maybe you can address that otherwise about what do we do with the presumption?
Well, Judge Lewis found that there was no violation of any law, no violation of any legislative procedure, and no violation of any court rule. So given that finding, there's no presumption.
Well, that's
he said,
not
as a
really—
finder of fact, I can draw certain inferences. I'm permitted to draw certain inferences.
He said that they knew as a moral certainty that there was going to be litigation. And when I look at our cases about where parties don't keep emails, I hate to use destroy, you know, it seems
They deleted emails in the ordinary course of business.
Well, except Dean Cannon said that he deleted emails after 6 months, but before the 6 months, this litigation had already been filed. So there, I think the judge said there was a moral certainty that there was going to be this litigation. And so I think that the issue of a matter of law, there was a duty to preserve, and an adverse inference comes from that, and that's what and he found that. The judge found that.
He found that. He found
a
but he didn't
adverse
say,
inference from that.
but he also didn't say that because of that adverse inference, I now think that everything is tainted. He specifically also found that these 3 staff members were not tainted and that their testimony was credible. And they gave all sorts of testimony about how they drew maps. And when he went through the specific districts, he saw that the staff on some of those districts, the staff had drawn those maps the way that they finally were from the beginning. In the House, there were at first 7 draft plans that were submitted, and then they went down to 3 and then down to 1. And he said as to certain of these districts that they start, for example, District 13 and 14, that they started from the beginning, drafting it in that way. And so he used both the inference, but also his findings about credibility to determine which districts should be redrawn and which need not be redrawn.
Can we talk specifically about districts 26 and 27? That was where Homestead was divided. It wasn't divided in the Senate's draft maps, but it was divided in the Houses. When the Senate released its map, terra firma emailed saying District 26 was pretty weak. And Heffley responded, and these were the consultants or outside consultants, the House needs to fix a few of these. And he responded, yes. In the meeting that was non-public, and I understand it wasn't in violation of the government in the sunshine, 26 is divided just like the operatives said. Is that one?
Well,
do you have some other explanation for why 26 and 27 were divided? I mean, why Homestead was divided?
Again, that was drawn from the beginning that way. The House drew District 26 and 27 that way, splitting Homestead from 901 map. The Senate's iteration of those districts was much less compact. There was a shoehorn shaped district going around another district, and so it made it very non-compact, and the evidence was that they decided to use the House's version.
I guess my issue is we've got, apportionment 1, great assurances about how transparent everything was in the public hearings, and we really relied on this transparency, yet certain decisions, in fact 5 or 6 of them, were made not in the public eye. They were made in meetings that where little notes were made, and that's where District 5 changed. That's where District 10 got its appendage. That's where 26 and 27 were divided. That's where I think the concern becomes, once the judge had found that there was improper intent as the plan as a whole, that you look at these and you're a little more concerned about the justification for, say, splitting Homestead, just as an example.
Well, again, he found that Homestead had been, I don't know if he found this, but the evidence showed, and the evidence, the testimony from Pareda and Alex Kelly in the House was that had been drawn that way from the beginning. So that did not change. The only thing that changed at the meeting was going with the House's version instead of the Senate version. That's not what Judge Lewis was concerned about, and he took the testimony of the staffers into account in determining where he thought that the improper intent had been. And the undisputed evidence was that these meetings occur regularly during a legislative session. In fact, it's the only way to reconcile one map against another.
Well, why do they have to be outside of the, why do they have to be in private? I mean, if there's a decision made, again, like District 5, why does it have to be done outside of the, and I understand legally there's no violation, but if we're looking at trust and confidence, why does it have to be done? I understand everything, the reconciling of the budget, we understand all these happen at a leadership level at the end, but when we're talking about redistricting in particular, Why did that have to occur, the reconciling of the congressional redistricting?
Your Honor, I don't know about have to. Why did it have to? That's the method they chose. That was the the easiest method to make sure this got done on time. There was no discussion about why there wasn't a public, and I don't think the Constitution requires that they be in a surgery room with people, the public above, looking down on what they're doing, as long as there was no intent. The judge found that there was some intent as to some districts, and that has been remedied. So, but I don't think the Constitution requires that the reconciliation process be done in public. As to, unless the court has specific questions, as to the standard of review, no court has ever held that strict scrutiny applies in a VRA challenge. And so to the extent that the Florida Constitution mimics the VRA, it's not a strict scrutiny standard of review. This court never used the word strict scrutiny in Apportionment 1, Apportionment 2, or any other apportionment case. And Judge Lewis really faithfully applied what this court did in Apportionment 1.
But why isn't the other party correct that in Apportionment 1 we were not dealing with any kind of finding that there was any kind of constitutional violation? And so once you get to that point, isn't there a different standard that should be applied than one where we are simply giving deference to what the legislature has already done?
They are incorrect, Your Honor. Apportionment 1 did find that certain Senate districts had been drawn with improper intent. They did find that. And still, when they were...
Is it the improper intent
regarding, I think it's Districts 10 and 13.
That we are talking about now with the partisan...
Yes.
Okay.
Yes, they did.
Okay.
Yes. In Central Florida, that there was a certain district that was drawn to favor...
You're talking about the district in Orlando?
Yes.
Okay.
And that was redrawn, and the court approved those districts. And once the court found that Central Florida was drawn with improper intent, it did not say, well, we're now going to put on dark-colored glasses and look at everything through a different lens. It just went through and approved 32 districts and disapproved of 8 districts.
I think what Justice Quince is referring to is, even though there's some belief that we found the Senate map was drawn as a whole with improper intent, all we said was that the numbering of the districts were improper.
No.
We never made, nor could we have made, because we didn't have factual finding, that the whole map was drawn with improper intent.
No, you drew an inference on CD 13 or
but I think what I'm getting is that we didn't get to a situation where there was a finding that the whole process was infected with improper intent. What to do at that point? Because we couldn't have, because we were doing a facial review.
But again, here we get back to Judge Lewis's findings about the staff members and his specific finding after listening to their testimony, and they testified about a lot of things, that they were not infected by the process. And he found that testimony frank, straightforward, and credible as to all 3 staffers. And they testified about each and every district.
But then if that's true, and since they helped with the 5 and 10, then your argument would be that there wasn't a way to even find 5 and 10 unconstitutional.
Well, we could have appealed that, but instead we just redrew the districts and did what the court told us. We don't agree with what Judge Lewis did as to 5 and 10, but his rationale was that the whole Pepper-Reichelderfer communication infected 5 and 10 because those are the districts that they were talking about. As to the benchmark, they discuss benchmark 2002 and CD3 in 2002. In Martinez versus Bush, the parties specifically stipulated that CD3 was not based on political intent. On footnote 93, I'd like to quote, it says, the plaintiffs and interveners do not allege, obviously, that these districts, meaning districts 3, 17, and 23, were politically gerrymandered in violation of the Equal Protection Clause. So District 3 in Martinez was not found to be politically gerrymandered, and the court found that it was reasonably compact and complied with the VRA.
That they were saying it wasn't a, the Davis versus Bandemir, I mean, it's a very high standard under the Equal Protection Clause to find that a partisan gerrymander is going to be an equal protection violation. But
these were minority districts, and so the court was saying...
I thought the court said that they didn't find that race motivated it. They found that partisanship motivated it.
But that's the quote that I gave you, is that as to CD13, they weren't arguing that it was politically motivated.
Which was, I'm sorry, and
CD3, which is now
became
CD5.
5. Got to have a roadmap.
Right, exactly. Well, it's basically the same district. On their CD5, first of all, it is less compact than our CD5 under the REOC score. It is more compact under the convex-Hull score, but that's because under that score you can have a 1,000-mile-long, 1-inch wide district that would be a 1.0 convex-Hull score, because all that measures is rectangularity. And so this was rectangular, and so yes, it's going to have a good convex-Hull score. But it does not have a better REOC score, and as the court found, their CD5 renders then CD2 extremely long, over 232 miles long, I think it was, versus like 146 for our CD2, and extremely non-compact. And so the court said, well, you're just trading off one for the other, even assuming that your CD5 is better.
I guess I thought what the judge did when it came back was, and again, I've got to look back at it, was that what he said is, no, I see that the East-West makes sense. It has good scores, but I'm not going to require the legislature to pick, quote, the best plan. Did he not? I mean, I didn't think he criticized.
I don't think he said it. He said there were trade-offs.
Well, again, I didn't really, I thought he deferred, and that's what they were criticizing, that he deferred against the legislature, even though he had found this, because he said they don't have to pick the one the challengers want, and that may be true, but that he didn't use the same, that he was there saying he was overly deferential.
But he also talked about their CD2. It's not deferential to say you just destroyed the compactness of the adjacent district. I'd also like to point out that nobody in the legislature, either before or after the final judgment, introduced or voted for an East-West district. No Democrat introduced an East-West district. In fact, there was a Democratic alternative introduced on the remedial plan. It went north-south to Orlando.
Let me ask you that about the Democrats and Republicans. And Democrats may look at, when they were in the control of the legislature, as I think we said in Apportionment 1, it wasn't like this is a one party versus the other. This is when the party in power does what they can to keep in power. So when we're looking at whether the Democrats like something or the Republicans don't like something, or vice versa, aren't we to look at really what the voters wanted, which were, you know, fair districts, so that there weren't like just safe seats for Democrats and safe seats for Republican, but that there really could be meaningful competitive elections?
Your Honor, the Constitution does not provide for that. Amendment 6 does not say you have to draw competitive districts. In a sense, it says the opposite. I mean, it just doesn't talk about competitive districts, but it does say you can't favor or disfavor a party or incumbent. So it says we need neutrality. You need to draw compact districts. You need to follow geographic and political boundaries and let the chips fall where they may, is what they're saying. So if we drew districts looking at reds and blues and see, let's make them competitive, that would be blatantly unconstitutional.
But you have to look at, and I guess you've got to look at, you did, political performance. You've got to look at...
We did not look at political performance.
But now, when we're analyzing it...
Well, let me tell you about what the political performance shows and what the evidence showed about political performance. And this is on page 58 of our brief, and Pareda testified about that as well. If you take, first of all, the undisputed evidence was you can't just take one election in isolation. You have to go to at least more than one election. If you take the last 7 elections and look at the chart on page 58 of our brief, from 2010 on, the last 7 statewide elections, the remedial plan would vote in 122 Republicans. Romo A, which they say that's the map you should draw, 123 Republicans. So it's more Republican in performance than ours. If you take the last 13 elections, beginning in 2006, I'm talking about statewide elections, the remedial map would elect 209 Republicans. Romo A would elect 208 Republicans. So it's a difference of from 16 Republicans to 16.1. Not a statistical difference. And so if you want to look at political performance, that's what the evidence was. And that's why the judge was applying the law and not overly concerned because this was submitted in evidence, and he noted that our map eventually performed just as theirs did.
Well, let me ask too, and there's an interesting one with 13 and 14, which was another one that terra firma said it was the map, Tampa's far from perfect. And
first of all, the concept that a senator would publicly thank a co-conspirator for drawing his district is ludicrous.
Now, that it was far from perfect. Now, you have Pinellas going then into Tampa, and we know from the recent election that having Pinellas, not in Pinellas, but in Tampa, probably affected that district's results. So sometimes it's the subtle things that you only know when you are looking at actually what happened that is the best indicator that maybe there was, that this was done to help the District 13 be more Republican-leaning.
Let me respond to that. The evidence was that there were 8 maps that were submitted that had District 14 going into Pinellas County, including the NAACP's map. That went into Pinellas County. So if you infer that we were conspiring with Posada, then you have to infer we were conspiring with the NAACP, because we also thanked the NAACP for that district in CP 60, Coalition Plaintiffs Exhibit 60, at page 60. We thanked both of them. Okay, that district was going into Pinellas County. This court drew it that way in 1992 when it drew districts. It also drew it going into Pinellas County because the problem is minority performance. That is a coalition district in which blacks and Hispanics vote together to vote their candidate of choice.
Who's their and that's
I don't
Castor?
Recall.
Well, it's Castor.
Okay.
I mean, it's this idea that somehow
you
needed.
No, that's 13. I'm talking about 14.
And I see you know what? You're in your, I think your rebuttal, so I don't want to.
Please ask away.
No, thank you. No, I mean, I just want to, but it looks like 13 was not for Congress, was not a black.
No, I was talking about 14.
But maybe I'm convinced.
We had to have 14 going. Well, here's the thing: 14 goes from Hillsborough County into Pinellas, and then 13 is what's left of Pinellas.
Okay, so which one was looking to be made more competitive for
Not
minorities?
more competitive. It was already a performing district, 14, which is the one right below 13. And once you draw 14 that way, we drew 13 to have 19 whole cities. It contains 19 whole cities. If you see, it's very compact, and that's why there were many maps that drew it that way. It's very easy to draw it that way once you have the requisite number of minorities in 14. And that's another one that the House drew that way from the very beginning. And Jason Pareda testified, Alex Kelly testified, that's why they, from the very beginning of the process, they drew it that way, and that's why Judge Lewis found that there was no improper intent as to those districts.
I'll give you an extra 2 minutes in rebuttal since we helped you use that up.
Thank you, Your Honor.
Thank you.
May it please the Court. My name is Allison Riggs, and I represent the Florida State Conference of NAACP branches. The record before the legislature in the 2014 special session amply demonstrated why the legislature had to reject the remedial configuration of CD5 proposed by appellants and instead maintain the north-south configuration of the district as it had been since 1992. Two main elements of the record support this conclusion. The first is the NAACP developed a wealth of evidence during trial and then presented that evidence during the remedial session, and that evidence showed that black voters in this region have a shared history and are politically cohesive as a district. CD5, then CD3, was created as a remedy for decades of political exclusion of black voters in that region. And for over 30 years, well over 30 years, the NAACP has advocated for this district, and certainly not with any partisan or political point. It's to ensure that after not having an African-American congressperson since Reconstruction, that was remedied. And voters testified before the legislature during the special session that they have reaped benefits from being able to elect a candidate of their choice. They've seen increased funding for HBCUs. They've seen contracts available to minority citizens that weren't available before. These individuals also testified during the legislative session about the challenges that face black voters in the region, in the counties comprising CD5 in the North-South configuration. They testified how black candidates in these counties still struggle to get elected from non-majority black districts. They testified about the socioeconomic challenges that impede political participation in this specific region of the state. And that was the record before the legislature during the special session that justified the North-South configuration. In contrast, the East-West configuration proposed by appellants has numerous fatal flaws and cannot be a replacement for the North-South configuration of CD5 approved by Judge Lewis. As Justice Cantero mentioned, this is not a compact district. It stretches 206 miles from Jacksonville to Chattahoochee, with no evidence in the record about why that district makes sense for black voters. The East-West configuration of CD5 would diminish the ability of black voters to elect their candidates of choice. Looking at the 2000 midterm elections, which is probative of political behavior in a non-presidential election, we see that in the benchmark CD5, black voters were a plurality of the turnout. Black voters outnumbered white voters by a narrow margin, but still outnumbered them. This dramatically changes in the East-West configuration. Looking at the 2010 data for the East-West configuration, white voters were nearly 53% of the electorate, and black voters were less than 42% of the electorate. So it changes the characteristics of this district.
Can you just really take that election, the 2010 election, was, again, to me, we know it was an anomaly as far as what was happening. Obamacare had just been passed, and there was a big push during that time. So again, I appreciate what you're saying, but can we really just take one election and then say, well, that shows that this would be a failed district for minority candidates?
Two answers there. One, that wasn't the only indicator in front of the legislature. One of the vice presidents of the NAACP, Dale Landry, who lives in Tallahassee, testified as to why this district, this East-West district, was an illusion district, that he works there, he knows the turnout of voters in this area, and he was certain that that district would not perform. But also, of the elections that we had in front of us, that was the only midterm election that we had, and the burden of proof was not on the legislature here. It was on challengers to say that this district wouldn't diminish. All evidence is to the contrary. Another reason why the East-West configuration is fatally flawed is because it would strand tens of thousands of voters, black voters, used to electing the candidate of their choice in districts where they would not be able to do so. And that echoes some of the concerns that Justice Perry had in Apportionment 2 in the Senate map. In conclusion, the Florida NAACP respectfully asks this court to affirm Judge Lewis's determination that CD5, as enacted in the special session, is constitutional. Thank you.
Thank you. I'll give you an extra 2 minutes as well.
So that means I've got 5
You got
plus
7 minutes.
7 minutes. Thank you, Ron. The question that it seems to me that confronts you here is whether my friend's view of the conspiracy is the same as what your view ought to be. They seem to suggest that this grand conspiracy that these political operatives entered into with the legislators.
Isn't part of the question there, not for our analysis, is what the trial court's view of that was? But I mean,
yes, sir.
If there's competent substantial evidence for the findings of the trial court, we are going to be bound by those. Isn't that correct?
I think that's correct.
So a key part of analyzing this is understanding what the trial court actually found with respect to the conspiracy. You would agree?
I would agree. And what the trial court found specifically was that the legislators collaborated and cooperated with the political operatives. Now, I agree he said some good things about the staffers, but it seems to me that it's a lot worse when he tells in his findings that the legislators, and this is not some legislators in some committee or something. This is, we know about apex depositions. This is apex legislators. These are the legislators at the top of the legislators are collaborating and cooperating with the political operatives. So, since he's found that...
But weren't those findings, again, limited to specific circumstances with respect to specific differences that Mr. Cantero has gone through, and they're outlined in the order?
And we submit to the court that that's where the trial court erred, in finding that the conspiracy was so limited. It seems amazing to suggest that this grand conspiracy was all about a bubble of 30,000 people in Seminole County, which included Sanford, to be added to District 5, and an appendage in District 10 to kind of help Congressman Webster have a few more of his prior district. That's not the extent of what we proved at the trial. That's not the extent of this conspiracy. The conspiracy had a much broader perspective as we established at the trial.
But how can you reconcile that with the reality of many of these districts that you're challenging having been drawn that way from early in the process by the staffers who the trial court found were insulated from that external influence and the conspiracy, and who had pure motives?
Well, let's apply that to an example. To 26 and 27. He said it was drawn that way from the beginning. Well, the beginning, as far as the public map, was 9001, which was released on December 6th. The original map was Coalition Plaintiff Exhibit 1037, which is in evidence in this case, was done back in November and did not split Homestead. Now, the conversation that you have heard about between Mr. Heffley and Mr. Terra Firma occurred prior to December the 6th. The House fixed the problem. That was the evidence that we established in the case. As far as District 13 is concerned, District 13, my friend says, well, there were some other maps that were offered that established that split Pinellas County. Well, in the first place, Pinellas County was not split in the Congressional District in 1996. It wasn't really split until 2002 when the gerrymandered political map was created. But in the earlier version of this, there were a few split, but none of the public maps matched 13 in performance as did the Posada map. The map that was created by, Terra Firma's fingerprints are all over that map. They couldn't find anybody to even shill for that map, so they claimed somebody's identity and put it in. It was the most aggressive performing map of any of the Republican maps, and 13 performed exactly the same. And of course, Terra Firma was the same fellow that Senator Gates was sending blind PSs to, hidden away in the metadata. That was one of the only findings that we got out of the records of the legislature. Everything else was scrubbed. We had thousands of pages about how you got to parking at one of the 26 public hearings across the state for the open and transparent process. But we didn't have any communications in the records of the legislature with the political operatives. They all somehow disappeared. Maybe it's a coincidence. But you know what somebody calls a coincidence? It's when you can't get behind the curtain and see the pulleys and levers back there. In this case, we got behind the curtain and we see the pulleys and levers. And it's not a pretty picture because it infused this map with partisan intent across the entire scope of the map. They hide behind minority protection. They say we're just doing it for the protection of the minorities, and yet they are actually harming the cause. When they reject the opportunity with the East-West configuration to have another minority-performing district in Central Florida that would result, they say they're concerned about the stranded minorities. Yes, sir.
I mean, their argument is that the evidence, at least from the 2010 election, is that that would not be a minority-performing district. So what evidence did you have that East-West configuration would be?
Here's the situation. The primary would be controlled 57% by the minority candidate. And if you look at the 2008 map, the minority candidate in the East-West division would have had 63.8% of the vote. If you look at 2010, she would have had 64.1% of the vote. And if you look at 2012, she would have had 64.2% of the vote. Those are landslide proportions, but they're not satisfied with landslide margins. They need avalanche margins. They want District 5 to perform in the 69% range because it serves their purpose, the pretext, so that the surrounding districts will perform Republican. That's the partisan taint, that's the partisan impact that this court's got to fix.
Do you impute that to the NAACP also?
No, sir. I think it's a terrible mistake on their part, but I certainly don't impute it. They have their position. I'm suggesting to you how you get more minority voters not to be in a stranded situation. I'm suggesting to you a configuration that will provide the ability to elect districts for 203,000 more minority voters than under the legislature's plan. If that's our goal, if that's something that we ought to consider. And the court said in apportionment 1 that was an appropriate consideration. If there are other minority districts that could have been formed and the legislature out of pretext fails to do it.
Your time is up, sir.
Thank you very much.
Thank you for your argument.
Thank you. I appreciate the opportunity for rebuttal. I assume that since it is a rebuttal, it's only for our cross appeal, so I'm going to...
And I did want to make sure I understood. What is it that you're cross-appealing? They
well,
say
let me,
you don't like the final judgment, but you're really not appealing it, and you're not appealing that you did what the judge asked you to do. So what is it that if you were to get relief...
We're appealing the judge's criticism of our accepting public maps, and we'd like you to vacate that part of the judgment which says that really criticizes us for having a process where we looked at 86 congressional maps. They said, the judge said in the judgment, well, you know, obviously whoever's going to submit a map is going to have partisan intent. So you should know that anybody who spends the time drawing a map does it for partisan reasons. So I'm not sure why you accepted it. But once you accept it, you had the obligation to go behind that and kind of do an investigation of whoever's submitting.
What part of the final judgment are you referring to? So you're asking for a vacation of a single finding of fact?
Well, I think just in your opinion, you can say that you reject that part of the final judgment that criticizes our acceptance of...
Is that really... You know, again, was that really a cross-appeal?
Well, maybe we didn't have to cross-appeal it. Maybe it's just you affirm it, but you reject that part of the reasoning.
We had to read an awful lot more pages.
I'm sorry?
So we had to read an awful lot more pages.
Well, that wasn't the only thing we did in our cross-appeal.
So is there one part of that, of his final judgment, can you just give me what page you're referring to?
I think it's when he was discussing public maps, Your Honor. I don't recall exactly the
okay, well,
the
you
page
have it.
number.
I didn't.
Well, the other part of your cross appeal brings into question the constitutionality of Amendment 6 based on the Elections Clause.
Yes.
And if that's true, then would the order approving the remedial redistricting plan, the revised plan by the legislature? Would that be invalid? So you go back to your original map that was drawn?
I don't think so, because the legislation adopting that map says, that's going to be enforced anyway. But it's certainly a constitutional issue for the future, capable of repetition yet evading review, that the court should consider.
So you're not, even under that argument, you're not contesting the redrawn plan?
No.
How would that evade review?
Well, it's not that it's evading review. It's that here you wouldn't be reversing because it's moot, but you need to, it's still an issue because the underlying basis for the final judgment would be vacated. There's no Amendment 6 in that event.
You have on the 11th Circuit ruled. Now,
Yes.
I know there's been some recent cases involving some other issues, which says, is the state Supreme Court or bound by what the federal court does? What is your view about what?
Well, you've never felt that way, Your Honor, and I don't think this court has ever felt that it's bound by 11th Circuit opinion, and
or
that the law isn't.
Any other than the U.S. Supreme
Yes,
Court, correct?
of course. And there was an argument yesterday in the U.S. Supreme Court similar to this case, not exactly because it concerned an Arizona redistricting commission.
Well, it's pretty different. That's pretty different.
Yes, but depending on the wording of the opinion, it may or may not affect our argument on the elections clause. If the court has no further questions, I ask you to affirm the judgment except for that part that criticizes our use of public maps. Thank you very much.
Thank you for your argument.
It's in this one.